So good evening to everybody. Welcome to the class. Let us the class will start it because it is the law of insurance and where we are making the thing. Before I could move further, that let me know that whether you could see the what I posted on the screen. Anyone? Just say that what I posted on the screen so that I could go ahead. Unmute and speak.
Professor Dr.
Ve-
Mohammed Sahib Hussain.
Very
Good
good.
evening.
Very good. Very good. So we are at the syllabus. We covered the first unit completely. The second unit also we covered the kinds of insurance, several interest, the premium. The last class we covered the risk. And this class that we will see the what is the certificate of insurance. So the certificate of insurance is the next class, and if the time would be left to be in this class, the time would be left over there. Then we will touch the what is the subrogation and contribution also. So let us start the certification, that is the COI. That is called COI, that is the certification of insurance. COI is the acronym. What is the certificate of insurance? COI. A certificate of insurance is issued by an insurance company or a broker or agent. The COI verifies the existence of an insurance policy and summarizes the key aspects and conditions of the policy. So, can I say that COI is nothing but the bond? Yes. Document. Give me the answer,
Sir,
madam.
it called as bond, sir.
Hmm?
It called as
Okay, it is a document which shows it. The certificate will be issued over that he is the policy holder. Is it not? Yes, the COI verifies the existence of an insurance policy that it shows it is in existence, the policy is there and summarize the key aspects and condition of the policy. For example, A stands for the COI is list the policy holder's name, policy effective date, the type of the coverage, policy limits, and other important details of the policy. That means whatever the policy terms and conditions should be there, which is in written form, that is in the COI signed by the parties. Yes, without a COI, a company or a contractor will have difficulty securing the claims. Otherwise, what is the surety or what is the bond that a person is a policy holder? So this is the certification which will be issued by the insurer to the insured. So without the COI, a company or a contractor will have difficulty securing the claims. Most hirer will not want to assume the risk of any cost that might be caused by the contractor or the provider. So either the insurance provider, there is a certificate should be there. If you make the FD also, they will issue a certificate, that FD certificate, a bond type. So that is the security for that one that you fixed this much amount in the bank. So it is also a certification. In the same manner, the policy holder also will get the certification. That is get a certification of certificate or certificate of the insurance. A company that hires a contractor or another assigned entity of the service should obtain a copy of the COI and ensure it is up to date. So it should also be up to date. The terms and conditions should be specifically mentioned. What will be covered, what will not be covered, including the nominee. Also be put it over there. Yes. Understanding the certificate of insurance. Yes. Certificate of insurance is used in situations where liability and significant losses are of concern and require one which is most business context. What is the certificate of insurance used for? That means the small business owners and contractors often have a COI granting protection against the liability for the workplace and accident or injuries. So the COI is there nothing but a guarantee would be there for the workplace or the accident or injuries where this insurance coverage would be there. Yeah, the purchase of the liability insurance will usually trigger the issuance of an insurance certificates. Yeah, the purchase of the liability insurance will usually trigger the insurance of an insurance certificate. So a policy holder definitely will get the insurance certificate that he is insured, the document. Without a COI, that is a certificate of insurance, a business owner or a contractor may have difficulty winning the contracts because many companies and individuals hire contractors. The client needs to know that a business owner or a contractor has liability insurance so that they will not assume any risk if the contractor is responsible for the damages or injury or the substandard works. Even for the masons also there is a insurance. Even the casual laborers also they will give the insurance. A low premium will be paid if any untoward incidents happens over there. For these, especially those who are working in the building construction is concerned, yes, they will be insured. Of course, if they are not insured over there, then the group insurance will be made by the contractor and who is hiring them for the building the for the building construction. Rather, we can say building construction or construction of the buildings. Yes, validating a certificate of insurance. How a validating of certificate of insurance? Typically, a client will request a certificate directly from the insurance company rather than the business owner or a contractor. I repeat, typically a client will request a certificate directly from the insurance company rather than the business owner or a contractor. Yes, they need the certification from there because he is the insurer. He has to certify it. Then only the people will work under you. Otherwise, they don't work under you because untoward incident happened to be there, then the coverage will not be there. Hence, that is the one of the certificate is must. The client should confirm that the name of the insured on the certificate is an exact match of the company or the contractor they are considering. So even though who are covered, the exact name also we should be mentioned over there in the certification. Yes, the client should confirm the name of the injured on the certificate in is an exact match of the company. Then who is injured, it should be the name of the injured would be exact what is given the name and the on the certification. Yes, also the client should check the policy coverage dates to ensure that the effective date of the policy is current. So if the policy is expired over there, then naturally one will not claim there any compensation or liability would be there unless until it will be renewed. Yeah, the client should secure a new certificate if the policy is set to be expired before the contract work is complete. So if it is an expiry period would be there before it is expired, then one should have to make the insurance immediately from the next day. Yeah, so that the continuity would be there. So what are the key takeaways in the certificate of insurance? Number one, a certificate of insurance, that is a COI, is issued by an insurance company or a broker and it verifies the existence of an insurance policy. Yes, whether the insurance policy is there or not, by looking at the COI, it can be known that who is the insurer and who is the insured, what are the coverage would be there, what are the rules and regulations would be covered, and what the liability would be there. The extent of the liability also clearly mentioned in the certificate of insurance. Yes. The second point is small businesses, owners, and contractors typically require the COI that grant the protection against the liability for the workplace, accidents, or injuries to the conduct business. Even for the some businessmen also would like to come under this insurance coverage because they're the people who will work. If any untoward incidents happen, then the insurance will come to the rescue. That is the workplace accident or injuries or that to conduct the business. The third point, it is a valid. It is a vital that the client checks the policy coverage dates and the limits of the policy. Yeah, it is a burden of the insured, that I mean the policy holder to check the whether the insurance cover is there or not, and what are the limits and what the liability would be there for this coverage. So time to time they have to make it out so that they could sleep in comfortable way and they can reduce their even BP and sugar also if they one is insured. Yes, the details of the certificate of insurance. Let us see the what are the details are there in the certificate of insurance. Yeah, certificates of insurance contain separate sections for the different types of the liability coverage listed as general, auto, umbrella, and workers' compensation, insure, refer to the policyholders, the persons or company who appears on the certificate as being covered by the insurance. So, who are to be covered, who are not to be covered, will be clearly written in the insurance of that certificate of insurance. And that is the thing. Then another coverage also there, different types of the liability coverage listed as general. Auto coverage is there, umbrella coverage is there, workers' compensation coverage is there or not, insured prefers the policy holders, the persons or company who appears on the certificate as being the covered by the insurance. So who is to be covered, who is not to be covered, they clearly mentioned in the insurance certificate. In addition to the coverage levels, of course, limited liability or the full liability, whatever it may be, that will be clearly mentioned. If the booty is more, if the amount we are going to get is more, the premium also more. So the certification includes the policy holder's name, So what is the certificates and includes the policyholder's name? Yes, the name of the policyholder should be there, and mailing address, and describe the operations and insured performs. So other description of the operations should be there, whether it's a monthly payment or yearly payment or half yearly payment or quarterly payment. That is specifically mentioned in the that is the certificate of insurance. Yeah, the addresses of the issuing insurance company is listed along with the contact information for the insurance agents or the insurance agencies contacted or contact persons. If several insurance companies are involved, all names and contact information are listed. When a client requests a COIL, yes, a COI is requested by the client, they become a certified holders. Yes, at the time they will become a certified holder. The client's name and contact information appears in the bottom of the left-hand corner, along with the statements showing the insurance obligation to satisfy the client of the policy cancellations. So the description should be given over there in the certificates regarding the client's name, and the contact information appears on the bottom left hand corner, along with the statement showing the insurance obligation to notify the clients of the policy cancellations. So the point comes over there. The certificate briefly describes the insured policies and what are the insured policies and limits provided for each type of the coverage. For example, the general liability the general liability section summarizes the six limits and the policy offers by the category and includes whether the coverage applies on a per claim or per occurrence basis. So per claim or per occurrence basis also there, and we will see it how the coverage applies over there, whether it be on per claim or per occurrences basis. Because the state laws determine the benefits provided to injured workers, the workers' compensation coverage will show no limits, and however, an employer liability coverage limits should be listed. So, what is the maximum limit and what is the minimum limit for that? It depends upon the status of the person who is working under him. So these are the things should be there. What are the coverage and the implies liability coverage limits should be listed. That's clearly shown over there. So these are the certificates which are essential because that shows the policyholder name and age and addresses and what is covered, what is not covered. Also clearly mentioned over there in the certificate of insurance. This is generally used to be asked in the short questions. This question. Yes. Any other thing that you would like to ask me? Aruna Kumari, Aruna Kumari, you'd like to ask me that if you want to ask anything. What is the
No,
certification?
sir, no.
Now, what certification that you'll use? Can you
I
give
don't
some
understand.
details about the certification of insurance where you are working? Yes.
Yeah, we need policyholder name, standard proofs, and who is the nominee and family details,
Okay.
etc. They need to fulfill, sir. After
Okay.
fulfilling, we will
Uh-huh.
have to take health one, what that?
Health certificate,
Health
medical
checkup,
certificate.
medical certificate.
Mm-hmm.
After checking the medical certificate, then we have to pay the policy. If there
Okay.
is any previous policies are there or not, some terms and conditions are included.
Mm-hmm.
We need to fulfill all it. Then only the policy will take it, sir.
Okay.
And
Suppose if you have
the age is main important.
suppose you are a defaulter, it will identify it in other
Yeah,
policies
identified, sir.
because it's the
Because of by saying a previous policies only.
okay. Because it is a computer recognize.
Yes, sir. Computer will recognize.
But,
Everything will be database, sir.
okay,
Everything will be
okay,
online.
okay. And this policy will be a printed form or it is generated by the computer nowadays?
Printed form, sir.
Not generated by the computer.
No, not generated. The
So
printed automatically.
that will be sent to the policy holder to his residential address by the registered post. Is
What,
it?
sir?
That will be sent to the policy holder by the registered post.
By registered post, by also through the agent also.
Acha, through
Through
agent also can bring it and give
bring
to
it.
the policy holder.
Yes, sir.
Okay.
The address will mention, that address will go to the that policy bond, and if the address will be changed, then the
What,
agent will take it, and after
uh-huh.
that they send it.
What is another name for the certificate of insurance? Can we say bond?
Bond also, sir.
Okay, that is nothing but it is a proof that the proof, a documentary proof between the insurer and insured,
Yes, sir.
and the other terms and conditions and who will be the nominee and what should be covered, what should not be covered also there, depending upon the type of the policy.
Yes, sir. And the nominee should mention the relation, sir. Must and should.
There is what would be the nominee relation?
Yes, sir. The
Okay,
if the children are not there, wife or dead, or any
okay,
spouse are dead, if the policy will taken, the relation means, and the wait. If any, that means that we can say.
Can we submit a certificate also regarding the
Ah,
relations with this?
no, sir. If wife or children's means no certificate needed.
Okay,
Any దత్తత తీసుకున్న పిల్లలు గాని or else any
okay.
charity mention చేసే వాళ్ళకైతే definitely certificate needed, sir.
Acha. So that is the proof should be there. Huh?
Yes, sir.
Okay. So yes, that is a certificate of insurance is nothing but a document which will be shows the relations between the insurer and insured. That is the proof for that one, is it not?
Yes, sir. Yes.
Okay. So this is generally the we can see in the short questions that we can expect such an answer. Then if we go through the next point is concerned, that is subrogation, doctrine of subrogation and contribution. That is the next. We'll throw light. Then we'll see how much we can cover. In that one, we will see it. Yeah, subrogation. Yeah, this is the next point. That is subrogation versus contribution, and what is the difference and how it can be made. What do you mean by subrogation and contribution? Okay, ever wondered about the
Most
difference?
important is a sign talation, sir. When the
Ah,
policy when the policy taken, sir, the policy holder what he signed it after the taken the completion of her policy, the sign must be matched. If it is
okay.
not matched, then the policy amount he can't take it, sir.
In case, suppose the policy period is the 25 years that he made it out. In the 25 years before, his signature is a bit different. After 25 years, because of the age and other factors are concerned, if it is a little difference would be there, then again they would like to ask us to sign or it will be certified by the expert.
That means previous signs he need to tally, sir. Maximum probably 90% they can't give. If
Okay,
any serious position is another proof seen, sir. That means photo and her ID proofs and her what he make the relation of wife, what he
okay,
mentioned in everything. He have
okay,
to explain. He have to submit it and he have to prove it, sir.
okay,
After that
okay.
only they can give the amount.
Of course, such a cases are very rare comes in the signature is
Yeah,
concerned.
rare, sir. It's rare cases.
Suppose if the thumb impression.
Thumb impression means no problem, na sir. Easily
Because
can take it.
yeah.
Easily.
Yeah, it will not change it. Of
Yeah, it
course,
will not
because
change.
the lines may be worn out because of the age, because of the many other factors are concerned, but generally thumb impression will be as it is because it cannot be copied, it cannot be fabricated, it cannot be fake. So,
Yes.
oh, yeah, that is the truth because even for the checks also, when you are signing on the check, a little difference would be there. Again, he will say, "Sir, can you check again here in front of me?" Then he will check it. Then he will say, "Okay, the same person," because he can identify by his face as well as his photo, which is fixed over there in the computers. Yes, these are the things when case of doubt or concern. Yes, because they want to clear it, whether the signature tallies or not at the time of the maturity or taking the amount. Yes, they will definitely make it tally. Even for the if you go for the even for the 100 rupees, 200 rupees, they don't tally generally the signature. But when you want to draw the 1 lakh rupees to 2 lakh rupees, they will check again. Sir, can you have the ID card? Can you have the book pass? And so when you have the so and so, so they will ask the several questions so that they will ascertain that it is the same person who came to the bank and drawing that much amount. Otherwise, no, it will go into the wrong hands. Then the bank will be held responsible. Okay. Now let us see that what is subrogation and contribution is concerned. So ever wondered about the differences between the rights of subrogation and the rights of contribution? It really comes down to who is prepared to share the cost of the exposure. As dry as the topic can be, the difference is becoming a critical in contracts that requires you to have certain clauses in your insurance policies. Yes, some of the clauses they have to put it over there in the policy that to consider this, and a contract requires your client's insurer to waive their rights of subrogation. A claim occurs, the other party to the contract try to assert that your client's insurer can't seek contribution from their insurer because of the waiver of the subrogation. So here are the terms of the subrogation, whether the waiver is there or not. We'll see how it can be make it out when you go detail. Yes, come to the matter of the subrogation, and it is an insurer's right of subrogation, okay, arises when they insure a person for an insured loss, and that person has a legal right to make a recovery against a third party who has caused or contributed to the insured loss. Suppose if the loss or injury is caused by the third party, then the insured will try to get that compensation from the third party. And a simple example is, let us see with the simple example, is a motor vehicle insurance, and where an accident is caused by the fault of another driver, and the vehicle owner's insurer agrees to pay the for that repair, the insurer can recover the repair cost from the at fault driver. Yes, he can make it out of from the fault driver because he was ready to pay the losses which is occurred to the car. Yes, for the damage in the car. Or yes. So where an accident is caused by the fault of the another driver, the opposite driver, and the vehicle owners means a person vehicle owners insurer agrees. If that vehicle insurance owners agrees to pay for the repair, the insurer can recover the repair cost from the fault driver. At that instance, even the insurer can also, of course, the insurer can recover the repair cost from the fault of driver. But the first and foremost, the insurance company will pay it. Later on, they recover from the person who is the third person who caused the injury to the owner of the vehicle. Okay, this is nothing but the bailment. First, they make the bailment. Later on, depending upon the fault, whose fault it is there. Suppose the other party fault is more, then they can recover from the other party. But first and foremost, they have to pay to the insured. However, the insurer's ability to recover depends upon the owner's legal right. If the owner had already released at fault driver from the liability, they have no legal rights, so the insurer has no right. For instance, if you take the insurer's ability to recover, the how a insurer will recover it depends upon the owner's legal right. So, what is the owner's legal rights are there? And if the owner means the vehicle owner had already released the at fault driver, suppose he says, okay, if the fault driver says, sir, I'm a poor man, sir, I'm only for this job for my livelihood, sir, because I don't have any other thing except this one, because the mistake it has happened over there, sir. At that instant, the fault driver says to the driver, the owner of it, if he waives, means the owner of the vehicle waives not to claim from the fault driver from the liability, then they have no legal right. So the insurer also have no right. Suppose the owner will not file any case or he will not realize anything. At that instance, in the insurer also cannot have any right and to claim anything because the owner itself is silent and patient. Then the insurer should be silent and patient. So that is the point which I want to say. So this is why the insurer don't like it when an insured agrees to hold harmless clause in a contract. Of course, such a clause will not be there. Otherwise, if it is there, there is no question of the playing the role by the insurer. So that was the thing which will come into the picture. So that is the way of the subrogation. If the payment is not made by the default, of course, the defaulter is says that I did not have the money. At that time, the owner is says waived it. At that instance, even the insurer also can ask to waive it, but insurer doesn't have any right to claim such a thing which is not claimed by the owner. Yes, and then let us see the contribution is concerned. Insurer's right of contribution are completely different. So this is the insurer's own legal right under the Insurance Contract Act. It does not depend on the insured rights. So what is the insured rights is not depend the contribution is. It exists where two or more insurance policies cover the same loss. Suppose two or more policies covers the same loss, then the two policy holders supposed to pay it because because the insured is paying the two different policies with a different premiums. Yeah, the insurance who pays the claim can require the insurer who pays the claim can require the other insurers to contribute. Suppose the one insurance paid the entire compensation, then it should be shared by the other insurers also to complete such a contract. Yes, that is why insurer will not usually waive their right. The insurer means never they will waive the right of contribution of the or treat their policies as the primary to another policy. So they always treat their policy as the supreme policy. Who? The insurer, because it is the insurance company which runs the insurance. It's insurance. Yeah, that's why they price themselves. కాకి పిల్ల కాకి ముద్దు అంటారు. ఎందుకంటారండి? Yes. Unmute and
They
give me the
love their
answer.
children, sir.
Huh?
They love their children, so they call him like
Yes, yes.
son.
Even the insurer also they want to love their own things, so you want to protect it, and that's why they don't keep anything which is cause loss to them. Such condition. So that is the insurer will not usually waive the right of contribution to treat their policy as a primary. So he will not generally waive it because that is the thing. If he waive it, he would not get it anything. Yes, waiver of subrogation are useful to protect the someone from the legal action brought by an insurer, but they don't enable their insurer to avoid the claim for contribution by their insurer. So now let us see the waiver of subrogation. Means subrogation waiver means what is the paid over there? It should be paid by the defaulter. So waiver of this subrogation are useful to protect the someone from legal action brought by an insurer, but they don't enable their insurer to avoid the claim for contribution by the other insurers. Yes. So the contribution of the other insurer is must because the two or more insurers are there for the same cause of action. At that instance, the other will have to contribute it because the premium paid by the insured is for the two insurance companies. Is it or not? Yes. Give me the answer. For the same cause of action, for instance, you take the home and you have insured the home with one insurer company with a higher rate or another insurer company with a lower rate of the worth of the house. At that instance, when you are paying the premium and the two places, can you enjoy the benefit of from the two places? Yes.
That means two insurance companies are different, sir.
Yeah, two companies are different.
But you're saying two insurance companies. Yeah, both we can take the amount, so we can enjoy the amount now.
You can enjoy the amount because he's paying the premium for the both of them. Is it or not?
Is if one of the policy is taken LIC and
Yes.
another is HDFC or another bank, you're
Okay.
paying both the premiums for LIC and HDFC bank. We take
Yes.
the after that maturity amount is completed, then we
Yes.
can take it the
Yes.
amount from both the sides, na?
Both the sides will get the maturity things
Mm.
and capital
Yes,
amount
sir,
with the
that's
interest, roughly interest also. Is it or not?
uh, yes, sir.
Do they add some of the interest or not? The same capital amount will be paid.
Different, sir. Capital amount is different.
Okay.
And the premium also different. And GST tax, including GST taxes,
Uh-huh.
also different. For LIC, different GST, and another bank sector or biking, whatever maybe, that GST also different, sir.
Acha, 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 acha,
Including
acha.
GST, we have to pay the premium, sir, for everything.
Okay, okay, okay. But anyway, it's the plus point. The whole amount, some of the bonus also will get it.
Yes, sir.
Okay. So subrogation and contribution, just we saw it, but we go in the detail in another file. It is mentioned here. The another file also I have regarding the subrogation and yes, which I put it on the board. Yeah, and here I put it subrogation. Yes, here. So, doctrine of equitable subrogation in Indian law, how it can be made. So, the term subrogation in the context of insurance has been defined in the Black's Law Dictionary. Thus, the principle under which an insurer that has paid a loss under an insurance policy is entitled to all the rights and remedies belonging to the insured against a third party with respect to any loss covered by the policy. Suppose a third party is at fault. At that instance, whatever the amount paid by the insurer to the insured, because he is the policy holder, at that instance, that all the amount would be claimed from the third party when the third party is at the fault. So the principle under which an insurer means a policy, a company which making the insurance that has paid or loss under an insurance policy and is paid to the insured or loss covered by that insured policy is entitled to all the rights and remedies, whatever all the rights and remedies belonging to the insured against. So whatever the rights and the remedies belonging to the insured against a third party with respect to any loss covered by the policy. So right of subrogation is statutorily recognized and described in section 79 of the Marine Insurance Act 1963. So it did not say about that transfer of property. Sorry, the another insurances. It having a different insurance, that is the section 79 of the Marine Insurance Act, because it covers the marine insurance, which the premium is more, and in the marine aspect, because the probability of drowning is more, and hence the premium is more, and it will be actually work, and that's why there is a separate act is made. There is the Marine Insurance Act of 1963. A subrogation is the right, okay, rights of the insurer to assume the rights of the insured. Legal rights are to step into the shoes of. Yes, the rights of subrogation can arise in three different ways. So now the insurer will step into the shoe of the insured, then he claim the compensation or the amount from the third party and whose fault the accident or incident happened. Yeah. Next is subrogation by equitable assignment. So what is the equitable assignment subrogation? We will see in this one. So subrogation by contract commonly arises in the contracts of insurance. So that is the doctrine of subrogation confers upon the insurer the right to receive the benefit of such rights and remedies are the assumed has the right, and that remedies in regard to the loss to the extent that the insurer has indemnified the loss and made it good. The insurer is therefore entitled to exercise whatever the rights the issued possess to recover the extent compensation for the loss, but it must do so in the name of the assured. So now here the insurance company, that is the insurer, will indemnified by indemnified if there is a fault from the third party clearly. So whatever the right the insured is going to get, that right will be come into the hands of the insurer. Then the insurer will claim the compensation from the third party, where the third party is fault at large. So now equitable right of subrogation, let us see. Then what is the equitable right of subrogation arises when the insurer settles the claim of the assured. Whatever the claim of the assured will be there, the insurer will make it out. So that the claim will be claimed by the insurance company. So that is the point which is want to say. So the insurer stands in the shoe. I told you, no, the insurer stands in the shoe of the insured. Yes, then he will claim. So subrogation is this sense is a contractual agreement for the transfer of rights against the third parties and is founded upon the common intention of the parties. But the term is also used to describe an equitable remedy to serve or prevent unjust enrichment which is not based upon any agreement or common intention of the party enriched and the party deprived. So one party is enriched, one party deprived would be there, so such would not be there. The subrogation is must, and where the insurer will step into the shoe of the insured and claim the compensation from the third party, and where the third party is fully involved in the accident or in the event, 100%. Yeah, that is the thing. Then we see the principles regarding the doctrine of subrogation in India. What are the principles used over there? So the principles related to subrogation can therefore be summarized thus. Number one, equitable right of subrogation arises. Number two, subrogation does not terminate, not puts an end. Number three, when the issued excludes a letter of subrogation. Then fourth, a subrogation enables the insurer to exercise the right of the issued. Then the fifth, where the accused, sorry, where the assured executed a subrogation come assignment in favor of the insurer, a contractual from the subrogation. Yeah, that also covers over there in the fifth. Then the doctrine of subrogation and the concept of subrogation or non-assignment is explained by the following example. So these are the things would be there. Let me see one after another. The points will be covered in the subrogation. So the principle of regarding the doctrine of subrogation in India, the point where that we will see it. So the number one, the principle relating to subrogation can therefore be summarized. Thus, number one, equitable right of subrogation. So now we'll see what is the equitable right of subrogation, where that it arises when the insurer means company settles the claim of the assured. So whatever the claims will be there, it want to settle its assured for the entire loss. So whatever the loss is there, entire loss, and they want to give the assurance that we will pay this much loss. Yes, the entire loss. When there is an equitable subrogation in favor of the insurer, yes, when the equitable subrogation is there in the favor of the insurer is allowed to stand on the shoes. Yeah, the insurer is allowed to stand in the shoes of the assured and enforce the right of the assured against the wrongdoer. Yes, at that instance, the insurer is allowed to stand in the shoes of the assured and get the compensation and get the loss from the wrongdoer if the wrongdoer is 100% wrong. Let us see the second point, subrogation. In the second point, subrogation does not terminate the nor puts to an end to the right of the assured to sue the wrongdoer and recover the damages for the loss. So subrogation only entitles the insurer to receive the back the amount paid to the assured in terms of the principle of subrogation. So in the equitable subrogation, they don't want to take the more. Whatever the damages should be paid over there, that much will be recorded from the third person. Yes, and we do have three, four, five, six, total five are there. Yeah, let us see how much we can cover because the time is now 5:43. Still 2 minutes are left over there. And yes, madam, can you throw light on something on subrogation, madam? Please. Yes,
No,
madam.
sir, I don't
So you did not have that much idea. Huh?
know.
Okay.
Total
Here, at least, yeah,
subrogation.
yeah. Here,
Yes.
subrogation in the
Yeah.
sense, whatever the amount paid to the insured, that amount will be realized from the third party when third party at the fault by the insurer. That is called subrogation. So the insurer will,
That means third party will be default now, sir.
yes, yes, third party, when the full wrong would be there by the third party, even that amount,
That third
which
party indicates as a agent also, no? Agent.
no, third party means the wrongdoer. For instance,
Wrongdoer.
accident is there. In the
Mm,
accident,
okay.
the opposite party is fully drunken. Driver is fully drunken. Number one. Number two, and his license is expired. He did not renew it. Number three, he came in the wrong side and collided head collision. At that instance, first and foremost, the insurance company should have to pay to the insured. Later on, later on, they can step into the shoe of the insured because it's the full fault of the third party, the opposite party. At that instance, that amount which they paid can be reimbursed by the third party because whose fault is there. So that is called the doctrine of subrogation. Yes. So you have some idea regarding this one. So let us see the
Yes,
tomorrow
sir. Now I
also.
got idea, sir. Thanks. Thanks
Yes.
for saying.
Yes, yes. Subrogation and the contribution, we will see the next class also. Then, if the time permits would be there, then we can, according to our syllabus, is after subrogation and yes, then we'll go to the point of rights and liabilities of the insurer and insured. What are the rights will be and liabilities would be there for the insurer and insured person when because of the certificate of insurance is there, which is nothing but a contract. So that we see in the tomorrow class. Thank you very much for patiently listening. I would like to be happy. I told you my principle. Even one person's also there. I will give the same manner as I am teaching to the 100 persons. With this, I would like to stop my class today. Then thank you. Goodbye. And we'll see you tomorrow at
Yes,
five
thank you,
o'clock.
sir.
Yes. Then end of the meeting.